Hey, I'm Nancy Cavey. I'm a national ERISA and individual disability attorney, and I want to welcome you to this episode of Winning Isn't Easy. We're going to talk about the standard of review and why it matters in your ERISA disability claim. But before we get started, I have to give you a legal disclaimer. The Florida Bar Association tells me that I have to give this legal disclaimer. It's not legal advice. This whole podcast is just my thoughts and commentary. But am going to, in this process, give you an overview of what's happening in the disability insurance world, the games the carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Now, you have heard me mention the standard of review in many podcast episodes and YouTube videos, but it's time that we dedicate a whole episode to discuss what the standard of review is and why it's important. So the topics are going to be disability plan documents matter concerning the standard of review that courts will use to determine whether your benefits have been correctly denied or terminated. We're next going to talk about, can a disability carrier plan's failure to reference specific plan provisions change the standard of review? And I'm going to talk to you about the 11th Circuit's standard of review in a de novo case. And that's important because the alternative standard of review is something called de novo standard of review. And that's all important. And it's one of the first things I always want to know when I'm looking at a case and talking to a prospective client. Let's take a break before we get started. Welcome back to Winning Isn't Easy. The 11th Circuit holds that the de novo review requires the courts to consider all relevant evidence. Now, if you've purchased your disability insurance policy or plan from your employer, any claim that you make is going to be governed by a federal law called the Employee Retirement Income Security Act, or as we sometimes refer to it, everything ridiculous in the state since Adam. ERISA is it's a very strange statute, and it's been interpreted over the years by federal courts and the United States Supreme Court. And one of the strangest things about ERISA is something called the standard of review. And that's the standard that a court uses to review a denial of disability benefits or termination of benefits. And that standard of review can make or break your case. So let's start out with a little history. The Supreme Court in a case called Firestone Rubber versus Birch held that the denial of claims under ERISA should be reviewed de novo by the courts unless the benefit plan or policy has language that says that the court has to defer to the decision of the plan or the disability carrier denying the claim or terminating benefits. De novo means the court consider this case independently. So in my view, the arbitrary and capricious standard of review ends up being a handcuff on the judge, and I'll explain why in a moment, versus the de novo standard of review where the judge gets to substitute their judgment. And this will make all of the difference in the world. By the way, I want to tell you, there's nothing in the ERISA statute that even addresses the concept of a standard of review. This is something that's been created by the courts. Now, if I had a choice, I want a de novo standard of review. So what evidence does a court consider under de novo? Now, I will tell you, there hasn't been a uniform answer to this question in the multiple federal circuits in the United States. There have been three approaches. The first is that the review is limited to what was in the claims file when the denial or termination was issued. The second approach is the review is limited to what was in the claims file when the denial or termination letter was issued, but under certain circumstances will allow additional evidence. And then thirdly, review should be based on all of the relevant evidence, regardless of what was before the disability carrier or the plan. Now, there are 11 federal circuits in the District of Columbia, and each has its own approach. I am primarily based in the 11th Circuit, which covers Florida, Georgia, and Alabama. I do practice all over the United States, and I'm familiar with each circuit's rule. But for the first time, the 11th Circuit answered what should be reviewed in a de novo situation. This is the case of Harris versus Lincoln National. And Harris filed a claim for benefits against Lincoln. And at trial, Harris attempted to submit updated medical records and an affidavit. The lower court said no, and ultimately he appeals to the 11th Circuit. Lincoln said, look, there shouldn't be an unfettered right to introduce new evidence. There should be a showing of good cause at a minimum to present new evidence in an ERISA case. The 11th Circuit shut down that argument and sent the case back to the federal district court to consider new evidence. Now, we don't know ultimately what happened in this case, but that was a great win, particularly in the 11th Circuit, which tends to be rather conservative in its approach to ERISA disability cases. So that was a great win for Mr. Harris. It was a great win for those in the 11th Circuit where the applicable standard is the de novo standard of review. I hope you have learned a lot today about the difference between the de novo standard of review and arbitrary and capricious. Because as I've said, this really is the first thing that I want to know. I mean, I want to know who's the disability carrier. I want to know what your medical problems are. But the next thing I want to know is what's the standard of review, because that will impact our remedies, how we go about framing the appeal, and ultimately the decision that we can anticipate from the court. Remember, the de novo standard of review is a fresh set of eyes, where the arbitrary and capricious standard of review is that handcuff on the judge. Got it? All right. And I promise there's no quiz here. I'm not going to send you a quiz at the end of this podcast or episode so that you can see if you understood the difference between de novo standard of review and the arbitrary and capricious standard of review. Okay? I hope you've enjoyed this week's episode of Winning Isn't Easy. And I would ask that you consider liking this page, leaving a review, and sharing it with your friends and family. Better yet, would you subscribe to this podcast? You'll get notification every week when a new episode comes out. And I hope you tune in to our next episode of Winning Isn't Easy. Thanks.